Welcome to Solving Citizen Legal Encounters. All right, today we're going to be back in Judge Peterson's court following up on the sex case as we're moving forward. So this hearing is definitely going to be interesting because there's going to be some things that she's not happy about. So you're going to see a different twist to things that's going on in this hearing. So let's check it out. Let's go.
State of Nevada versus Yuxia Zhang and Kimball Austin Sachs. Can I get appearances from counsel?
We were ready to the state.
Charles Goodham, 14879 for Mr. Sachs.
Good morning, Your Honor. Shetler, 47 for Ms. Zhang, who saw the court reporter in the, not court reporter, the translator in the courtroom and advised me that she did not need the translator. So we dismissed her.
Are they on?
Yes, Your Honor.
Okay.
Yes.
All right. This is on for both parties have filed motions to quash the bench warrant on the basis that the minor was what was originally, and I understand that there was a bench warrant that was issued with the failure to appear. I get it. That's not the basis, and we all know from what the court issued while we were here in open court, the Scrivener's error and was ultimately corrected. Basis for the court's granting, or the basis for the court's issuance of the bench warrant was the fact that there was a violation of the release conditions, that being that the child was not supposed to be in Ms. Zhang's or Mr. Sachs' custody and that was why the bench warrant was issued. It's my understanding, based on what has been provided in the motion to quash the bench warrant, that the child has been returned to the father. However, all I have is a piece of paper that's a receipt that shows that a ticket was purchased. I have no way of knowing if that child got on the plane. I have no way of knowing whether or not that was a valid ticket. I have no way of knowing whether or not, similar to what happened in this case where CPS saw the child get on the plane before and then the child was obviously returned, whether or not the child is back in their custody or not. And it's my understanding from the state's opposition that officers have attempted to go out and a new sign was placed on the lawn that said that we are no longer here at this property. So I have no way of knowing whether or not those release conditions are still being violated as we sit here today.
Well, Your Honor, I think that the state has a few representations to make on whether or not he was on the plane.
Okay.
So I did meet with, the State Department did contact me. The child did get on the plane.
Okay.
The problem being is he traveled with a Chinese passport. And so whether or not we will have information until he touches down back in the United States, I would have to continuously need the State Department's cooperation with that to make sure that he doesn't come back into this country. The concern from the state is still, I'll let them argue before I argue. I apologize.
That's okay.
So I think that we know that he's no longer in their custody. I think that the quashing of the bench warrant is appropriate at this time, and I'd like to point out a couple of things and concerns that the court might have. Number one, I understand that he was put in for the homeschooling, but additionally, prior to that, he was actually attending that school, that Christian Academy. That was the school that he was attending. So he was being seen daily by teachers, by other people who were interacting with him, by other people who were speaking with him, and all of them were mandatory reporters. None of them reported that they thought that he was being abused, that he was unsafe, or he was not well. I understand that at the evidentiary hearing, we had a doctor testify that he saw them 6 months prior. Dr. Semelka testified that he was there with another doctor and a nurse. Nobody was arguing that he was being abused. Nobody thought that he was in a bad situation.
I don't think that anybody is arguing that he was being abused, Mr. Goodwin. And you know what? Here's what could have happened in this case that didn't happen in this case. And it's not lost on this court that your client thinks that he can do things whichever way he wants and that there are not going to be consequences. Previously, Mr. Shetler brought a motion to change the conditions of the release so that Ms. Zhang could have her passport back so that she could travel in order to be able to get to see family members that I understand were ill. And the court granted that. Maybe had your client done the same thing, and Mr. Shetler's client done the same thing of a motion to modify the release conditions that they be allowed to have this child back, we could have had argument and addressed it, and maybe there might have been a basis to do so. But that was never brought to this court. Your client just took it upon themselves, and yours as well, Mr. Shetler, to do whatever they wanted to do with no regard to the orders that had been entered by this court.
Judge Peterson's definitely calling them out. In a couple of hearings back, they were still filing their own motions, even though they were assigned attorneys.
That's a problem.
Well, I would point out one thing, Your Honor, that I think is important here. When you go through the actual orders, I mean, it takes digging to find any kind of no contact order. It's not really listed anywhere, not put on there. And on the summons, it's handwritten in. So we don't actually, that's what's confusing about the whole entire situation and what happened with the order. So
You're telling me, are you literally sitting there telling me right now with a straight face that your clients did not know, based on CPS, based on the fact that their child had been taken, based on the fact that the child had been put on the plane before, that they were not disallowed from having contact with that minor? Is that the argument that you're trying to make to this court?
I'm trying to say that the legal mechanism for them to not have contact is murky, incredibly murky. That's what I'm saying. Because I understand that CPS made a finding in Nevada, but the child did not get returned to them in Nevada. In fact, what the nature of that CPS, and I was not privy to it. I have no idea what happened in the CPS hearing. This all happened years before I became counsel. So I am not clear on what could or could not be fairly imputed to them in terms of what their responsibilities and duties are. I acknowledge, and I think that, to be fair, I don't even know if this CPS record was substantiated because I haven't seen documents. All I know is that CPS seemed to have stopped whatever they were doing under the condition that the child returned to China, which the child did. They saw the child get on a plane with the father and go back to China. At some point, the child is back with them, but not in Nevada. So I personally am not somebody who practices CPS. I don't enter into that area of law. I have no idea what happens when CPS makes a finding in Nevada, but they're back with the child in a completely different state halfway across the country. What is the proper procedure, or what should happen, or whether or not they will at that point be entitled to have the child back? I have no idea.
He's a really good attorney, and he makes a great point. The judge created an order in one state, and CPS is investigating it in one state. Does it carry over to another state?
What I do understand is that there was an order that was written on the summons, but going through the docket and looking at these orders, I did not once see like a clear no contact order. And I don't know how much can be imputed by a handwritten summons, whether or not they received that summons, or if they were told by their attorney at the time, hey, here's the day that we got to be up here. Because it's not in any official order. And it's not in what would be things that I turn over, such as the information, such as other things like that, in this instance, the indictment. So I don't know how much knowledge was actually imputed to them in terms of what was and was not appropriate. And the other question is, if they're in Arkansas and they do have their child back, what is the correct procedure to know if they're even allowed to have the child back? Because they were interacting with sustained contacts with the government of Arkansas, as is shown by the state, and Arkansas didn't do anything with it. So I don't know how, if there is something that CPS is like, these are never to have these children ever, why it wouldn't be in a central database or something as soon as he's enrolled that child in school that something didn't happen, or did a medical record or something didn't happen. What I do think is that it makes a very, very murky situation, and I don't know procedurally what even is the correct path to go through here. I can only tell you what I saw by looking at the record, and then I understand that they didn't have the summons, but I did not review the summons. I was looking at the orders that were entered into the court, and I don't know what is and is not fair to impute to Mr. Sachs on what his knowledge should be of what is and is not acceptable behavior.
Well, we have three different hearings that I saw where it was specifically stated on the record by the judges, and it wasn't me because this case predates me, but that was specifically stated on the record of no contact with the victim in this case.
You let me ask, because the ones I saw were a summons, a grand jury return at that hearing, and the summons. What were the other hearings where he was instructed? I'm sorry, Your Honor.
I'm sorry. I had them last week when we were doing this, when we were doing the evidentiary hearing in front of Dr. Semelka. I don't have them in front of me right now.
The one
I did see them so that I can make that representation on the record that I did in fact see 3 different minute from hearings. And I'm sure that Rem could probably find those before the end, because I know she was the one that found them and brought them to our attention previously.
What I would say, Your Honor, is that the ones that I was able to see on were not ones that he would have been actively present and admonished personally by the judge. The grand jury indictment return, that's done with the chief judge and the prosecutor. It's not really done with him or with counsel present. The summons, like I said, I'm not sure if the summons was sent directly to him or to another attorney, or if he ever received it and the attorney just received notification. Oftentimes, when I get a bench warrant return on an indictment, I get a notification through the courts that say, hey, you've gotten arraignment on this date. And that's how I know and tell my clients to be there on that date. But I don't generally get the whole entire minutes or anything else that happened to that indictment.
Give me 1 second. We're gonna get the minute order. So on September 25th, that's the grand jury indictment.
I'm sorry, Your Honor?
Never mind. That's the grand jury indictment. I know that there was another one. There is only one? Okay. All right, so the only one is the grand jury indictment. Yeah, give me 1 second. The record in case number 3, C 3435540, 1 and 2. Yuxia Zhang and Kimball Austin Sachs. There is in the chat, Mr. Sachs has said, I need to make a record. Please get my counsel's attention ASAP. NRS 178.4745 parens 4. No contact orders cannot exceed 120 days. I request this court get my counsel's attention ASAP. I have held my hand up and you are remaining silent. That is a clear due process violation. We were off the record. So there is no due process violation. The court was looking up something and we went off the record specifically. I was not ignoring Mr. Sachs, which he likes to jump to the conclusion that this court is always ignoring him. I was not ignoring him. I was in the other room off the record, not on the bench.
You can tell she was definitely annoyed by that.
That being said, we quickly went through the minute orders. Obviously, I've only been back there for about 10 minutes, so I obviously didn't do a deep dive. I will note that based on the grand jury indictment, there were minutes that said that the bail was transferred with the added condition of no contact with named victims. And then there is the summons indictment that does have that additional information on it. I understand your argument, Mr. Goodwin. And contrary to Mr. Sachs's statement that a no contact order cannot extend for more than 120 days, it can when it is a condition of a release on bail. So that is an exception to that.
Your Honor, that specific statute that's being referenced is actually referring to no contact orders as a condition of bail.
Well, the court can extend it past that time frame.
That's correct, Your Honor. However, I believe according to the statutory language, it has to be renewed by the court every 120 days with a new order signed.
And Your Honor, that statute is a new statute, did not apply back when
It is a new statute. So it wasn't at the time. Listen, at the end of the day, it doesn't change the court's analysis of the fact that murky or not, if something's murky, you don't just take matters into your own hands. You reach out to your attorney and say, this is murky. There's a statute that says X, if it was in play when he decided to make this decision. Can you file a motion to change this condition? You don't just have the child return to you, especially like I said, if there was a separate CPS issue, which I don't know if there was or there was not, but if CPS had a separate order that he's violating, then he's in violation of that CPS order. My point being is that there was at least enough here for the court to issue the warrant as to being in violation of the release conditions. So that's where we're sitting as of right now. I understand, and I would like some argument as to whether or not, where do we go from here is my point.
And that was what the majority of what I was leading up to was, Your
Right.
Honor, is that because it was murky, and I understand that he's not just supposed to take it in his own hands, but I think that in terms of following court orders, Mr. Sachs generally does follow all of the orders the court puts out. This was sort of a difficult situation, but for the most part, he has been complying. The court has seen the ticket that they purchased for the son, and the State Department has confirmed that the child is no longer with them. So I don't know why we wouldn't quash the warrant at this point and allow them to continue to do this case. They were prepared to come out here for the calendar call before it was stayed for what is going to be a Nevada Supreme Court writ, and a couple of other things, but they have, for the most part, complied. And I think that there is no risk of him fleeing. If anything, the voluminous record would show that this is Mr. Sachs is here to stay for some time. And I think more importantly, that there is no indication that what he was doing was continuing to abuse or neglect the child. So I don't think that he is a direct danger. I understand the court's position, but what I mean is that the fact that he was seen at schools, he was seen by doctors, he was seen by people in the community, that what we have is a situation here where they likely should not have been with the child. But overall, they have complied with their pretrial release conditions. They have done what they said they're going to do. And I don't think that continuing the bench warrant or allowing or forcing them to stay in custody for the duration of this trial would be warranted in this situation. I think that we can keep the conditions as they are, as they have had good communication with the court. In fact, they reached out to say, hey, is it okay if we do calendar call via Zoom? So when it comes to these types of things, Mr. Sachs has been very diligent. He has been trying to comply with what the court said. And I think aside from this one situation, we don't really have this. And over a 7-year period, I'm not sure how many other people could make that same kind of statement. So with that, Your Honor, I request the warrant be quashed and we be allowed to continue this case.
Another outstanding argument. If he drops that attorney, I don't know what he's thinking about.
Here's the only problem. The bond at this point has been forfeited. So I know that he was out on bond, but the second that we issued the bench warrant, that bond got quashed or the bond got forfeited. So that was one of the conditions, was that he have a bond to ensure that he come to court. The other thing that I'm also concerned about is that now we have evidence of arguably violation of conditions of pre-release. And we had given Ms. Zhang back her passport. And now, while he might not flee, she's now got her passport back. So I'm very concerned about that.
I want to say three things, Judge. Sure. And while this is an unusual case in a number of ways, the fact that my client was very aware of what she could and couldn't do, hence the motion to get the passport. And I don't want to go backwards, but I'm receiving a lot of input on this case. And the fact is, the current statute, which requires the no contact order to be renewed every 120 days, it would probably behoove us to go through the record and look for that particular item. I'm not sure it's there. I can't tell you it's not because it's a voluminous record, but I did spend a fair amount of time on that issue. I do think that there's at least a technical issue there. That being said, my clients are aware of the sports rules. I don't think it was a murky issue in their mind, what was going on. I can only speak for my client. That they thought that didn't apply. Here we are. What do we do going forward? I don't think that they expect, I know that they did not expect the bench warrant to issue. If another bond needs to be obtained, I would ask the time for them to get that bond. I've had few clients in my 32 plus years as a lawyer this heavily involved in a case. And so I have no doubt that they can comply going forward. And I have no doubt that they can give this court the assurances you need to know that your orders are being respected and being followed.
All right, your client is saying bond has not been forfeited. I spoke to the bail bondsman, so if it hasn't been forfeited, then that's great.
I do think I saw the matter on calendar, but
It says, he further says, my wife does not have her passport. I know that that was released to her and she must have it because supposedly she went back to China. That was the whole basis for the court releasing it.
remember, we're talking about this gray scope of time. I think the passport's bounced back and forth a few times. The last time that I spoke about getting her passport back, there were some other conditions involved. And we did not follow through on that issue, if I remember, correct me if I'm wrong, but I think that the last time we talked about getting it, we did not follow through on that.
Oh,
It was interesting because I can't remember. I do remember one of the conditions was that she signed an affidavit saying the child's not with her in Arkansas and that she's not bringing the child back. And we couldn't meet with those
conditions.
We couldn't have a meeting of the minds.
Interesting. Okay.
And so, and
So, I mean-
I'm ready for argument.
Let me just say that let's look at that from that perspective. If one of the conditions of getting her passport back was that she not have contact with the child and that the child not be brought back from China, that in and of itself should have alerted both sides. And I know that your clients are making arguments in the chat of there's no order. Listen. Criminal is a little bit more willy-nilly than civil. I've found that out by being here. And so to the extent that there is not a written order, the same way that there would be in civil, that doesn't mean that your clients have not been admonished in open court that these are the conditions of their release. If I need to do an actual order that says your clients are to have no contact with the minor, I will do so.
It seems like Judge Peterson is trying to lock down every door of escape.
And I will have the state submit it and I will sign off on it. And we can make it clear. But there have been 5 other judges in this case before I got the case. And so to the extent that there were not orders that were issued, I don't think it changes the fact that there was at least a understanding, or should have been an understanding by both of your clients that they were not to have contact with this minor child. But so that we can button everything up and make sure that everything is clear, I'll be happy to sign an order that says so. I will hear argument from the state before I make my decision as to what I'm going to do.
Asking you not to quash the warrant. I think the court's actually correct. I mean, there was a summons that was given to the defendants. It had no contact order. They showed up for the initial arraignment. We have gone through this case for years now. It predates mine. We've had discussions in open court about the child being in China. There's no doubt about these defendants knew that they were not supposed to have contact with, not only from the criminal side, but also from CPS. If you remember correctly, in the charging of this case, the defendants are charged for the actions at UMC in January of 2019. Child is released. He does not get his medical care in early February of 2019. CPS and law enforcement goes back, takes custody of the child. At that point, the case is substantiated. They give the child to the biological father. They say he's going to stay with this biological father. But somehow when they go to execute the warrant on April 4th, lo and behold,
The child's in the home.
in their home. So they already knew. So then CPS has to come back out and the child has to remain in protective custody until they actually physically take the child to the McCarran Airport. And actually, Ms. Zhang is at the airport to say goodbye to her child because he is going back to China because they are not protective based upon their beliefs and his medical condition. I don't know when this child came back to the United States. I don't know how long they defied the criminal court order of no contact. We know as recently as early as August of 2024, they're asking for homeschooling of this child. I don't know how long prior to that this child has remained in their care and custody. And for Mr. Goodwin to say that Arkansas has done nothing is absurd. As soon as the evidentiary hearing was done on Friday, as a mandated reporter, I contacted Child Protective Services.
That's not what he's saying. What he's saying is prior to that. What he's saying is that had there been an order, what he doesn't know is had there been an order that they were to have no contact, that at the time that they tried to enroll the child in school or tried to homeschool, that there should have been some sort of trigger that let the school know that the child was not supposed to be enrolled in Arkansas because he was supposed to be with bio dad in China, and that should have triggered them to report the issue to the authorities in Arkansas. Is that your argument?
That's correct, Your Honor.
And I wish there was a system in place. There is no system like that exists. So that's the unfortunate part of child abuse, child neglect, and child protective services. We don't have a national system like that in order to do that. That would probably alleviate a lot of issues potentially in cases. And unfortunately, we don't. But at the end of the day, they knew they had this warrant as of Monday of last week. Prior to that, law enforcement, CPS had tried to go out to their house. They wouldn't open the door. I talked to the Child Protective Services worker. They're like, someone's in that house, but they're not answering the door. They have to assess that child. And instead of allowing CPS and law enforcement to check out that child, for them to make an assessment of whether that child was safe, the child was okay, and could potentially stay in their care, what do? They buy a one-way ticket for an unaccompanied minor from Dallas, Texas, back to China. They circumvent not only this court's order, but trying to circumvent Child Protective Services in Arkansas and law enforcement in Arkansas, all while out on bail on multiple felonies of child abuse, one count of child abuse resulting in substantial bodily harm, and 2 counts of child abuse. And so this gives no assurance. This should give the court no assurance that they will abide by any court orders. And then it becomes, it's going to be too late. Whether or not I can get his passport flagged in the system, the federal government will work with me in case the child comes back. Then I have to work with local law enforcement out there. And clearly they don't want to work with law enforcement out there. And now they claim to have moved. So they're in like an undisclosed location. They're a flight risk, not because I understand that they show up in court, but there's an active warrant and they're hiding from it. They're actively hiding from it. They put a sign outside that says, guess what, guys? No one's home. We're gone. No one's home. Their actions should give this court absolutely no assurances whatsoever that they'll abide by any of these court rules. And so because of that violation of the no contact, because of their active avoidance of Child Protective Services and law enforcement circumventing the systems that we have in place to ensure that this child is safe, they go around all of that and send the child back to China. I don't know, but somewhere in China. I know he landed in Shanghai. I have no idea where he's living. Unfortunately, he's not a naturalized citizen. So the State Department can't go out in Shanghai because the child is not a naturalized citizen of the United States. So they have very limited things they could do with the Chinese government because the child is not a naturalized citizen of the United States.
She definitely brought a strong argument to the court. But which argument do you think is better? The defense or the state?
Final word.
You know, I think that a lot is being pushed on the fact that he's not cooperating with the law enforcement and other things like that. And I don't believe that he has a duty to. I don't think any citizen naturally has a duty to always comply with what law enforcement's doing.
I issued a bench warrant. He's actively avoiding. I know you have a motion to quash, but that doesn't mean that there is not an active bench warrant that's out right now. And he is actively avoiding being able to have that bench warrant served. That's a problem.
No, he knows, he's aware of the bench warrant, and then we filed the motion to quash to address it without him going into custody, without him being shipped all the way from Arkansas back to Nevada. So I think that when we're putting on a motion to quash, it is at least fair to at least see what happens in that motion hearing prior to making that determination. Ultimately, Your Honor, I don't believe that. Austin, please stop. I don't believe that there is any way for the any way for the state to contend that the child was not in was being neglected or abused up until this point. And with that, Your Honor, if that's the biggest beef, is that he wasn't seen by Child Protective Services. Well, the child is with the biological father. The child went to the school, he went to these places. So ultimately, Your Honor, we are requesting that this matter be quashed and be allowed to proceed. this case just, in my opinion, really needs to get to trial. That's what needs to happen. I understand that we've got some things getting in the way of it. If we can quash this warrant and get this done, we can get this.
Your Honor, if I may briefly.
You may.
I know you had not heard hardly enough about this case, but I do think that it's important to remember it is a criminal case. It's not a civil case, right? If we were in here with parties who were fighting about money, court makes an order, everybody's going to comply with that order because the sanction there is going to be money. And that's just a different standard. Here where we've got, and I hesitate to use any word about the current status of it, but I think that we have to err on the side of their liberty, their constitutional protections, and their freedom. I think that what you talked about is a very good solution to make sure there's no question anywhere. And while, as in every case, there are some facts that are more challenging for me to try and fashion into any sort of relief, what we have seen and what I've seen since I've been on this case is that certainly strident and very vocal involvement, but continuous involvement during the course of this between the on-screen Zoom texts, the texts I myself have received, and the updates I received all morning long. I've just never had anybody more involved. I don't believe, despite the challenges my client has any desire to violate this court's order, and I can certainly assure you that A, the passport's still here, B, we're not going anywhere, and C, we won't have any problem complying.
What does he mean they're not going anywhere? Is he going on a flight too?
Thank you for giving me that few moments.
This court issued a bench warrant on the basis of there being a violation of the conditions, the pre-release conditions. That condition mainly being in the indictment summons that indicated that there was to be no contact with the named victim. That was signed by Chief Judge Linda Marie Bell back on September 25th of 2019. There was also at the grand jury indictment, there was a journal entry indicating that there would be, that the bail in the amount of $20,000 was transferred with the added condition of no contact with the named victims. At the time of that, the 120-day limitation was not in effect. That actually came, hold on.
Judge, I believe it was in 2023.
What's the statute again?
178.4851. No problem. And then there's 178.4845 that was enacted in 2021.
What I was looking at. So 178.4845 was enacted in 2021. So at the time that original order was put into place, that was not a statute that was effective. Likely what should have probably transpired is once that statute came into effect, and this was still an open case, we should have probably had an order that extended that, which the court could do under 178.4841 as a condition of pre-release. I could have extended that another 120 days, every single 120
Agreed.
days. So that is what the court is going to do now. Is I am going to enter an order that is extending that no contact order that will be in place from today until the time of trial, and or if we go more than 120 days, we will renew it in another 120 days. I need the state to submit an order on that for me. I am also going to, even though it was murky, the court does believe that Mr. Sachs, as well as Ms. Zhang, had at least a knowledge that they were not supposed to have this minor child in their custody. And therefore, based on that, the court does find that that was a violation of their release conditions. I am going to increase the amount of their bail. I will quash the warrant upon presentation of a new amount in the amount of $25,000 for each one of them.
That definitely changed the game now.
So I'm increasing it by $15,000 for each one of them.
May we just present that to Chambers?
Yes, you will have 2 weeks to get that presented. And if upon the time that that is not complied with, then the court will issue a no bail bench warrant at that juncture. So that is going to be an additional condition because I do find that that there is at least a basis for violation of the release conditions to increase the bail to make sure, and especially in light of the fact that while I know you say that they don't believe that they need to comply, there was a bench warrant that was issued. And the fact that they are actively attempting to avoid the officers in Arkansas is concerning to this court. I understand that you say that they are present all the time and are heavily involved in this case, and I have seen that. But that doesn't change the fact that what bail is used and why bail is imposed is to ensure that they are going to show up. And based on their current actions, it doesn't appear that they are complying and cooperating with law enforcement at this juncture. And so that's why I'm increasing the bond amount. The bench warrant is quashed as of today.
Thank
So I'll
you.
give you
Thank
2
you.
weeks in order to put that new bail amount in. If that is not done, then I will consider issuing a new bench warrant at that point. All right.
Thank you for your
Thank
time and
you.
patience,
Thank you.
Judge.
Judge Peterson definitely made some changes in this hearing where she's making sure they're accountable for everything that they're doing. We didn't know about the active warrant and everything else that was going on, and that the child came back and they shipped the child back out. A lot of good information here. So thanks for watching. Give it a thumbs up if you enjoyed the video, and I will see you around on the next update.